Well, good afternoon. I'm Tim Blotz from Fox 9 in Minneapolis. Welcome to our streaming coverage here of Day 11 of the federal civil rights trial for the three former Minneapolis police officers who assisted in the arrest of George Floyd. Now, these three officers are Tu Tao, J. Alexander King, and Thomas Lane. They are all accused of depriving George Floyd of his civil rights on May 25th of 2020. That's when he was placed under arrest after trying to pass a counterfeit bill at the convenience store there at the corner of 38th and Chicago. Derek Chauvin, of course, the fourth police officer on the scene that day, has already pleaded guilty in this federal civil rights case. He's also now in prison for the death of George Floyd, in fact sentenced to 22 years. Rob Olson has been in court in St. Paul. He joins us now. Rob, this trial is now into its third week, and one of the headlines coming out of court this morning is that the U.S. Attorney's Office indicates that they're down now to perhaps their final witnesses.
Yeah, asked this morning right away by the judge, how close are you getting here? Because again, they were getting to the end of the third week now. Now, remember, too, that there were 3 days last week when this trial was on pause. It paused Wednesday morning right away, so Wednesday, Thursday, Friday, nothing. So 3 days behind schedule. But she said that they have about 5 witnesses left, is what she said at that point. So I don't know if that means there's some flexibility or decisions to be made if there's a witness that will or will not be called. But so she said about 5 witnesses left. That would include one that just took the stand, hoping to be wrapped up tomorrow with the prosecution side of things, which would indicate then the defense starts their half of the case come Monday. Again, we don't get witness lists in this trial, so we don't know how many witnesses the defense has lined up to call. They may say that in questioning in court with the judge before the jury gets in. That's the only time we get indications about what will happen, and that's what happened in this case, is they said before the jury was called in today that they had about 5 left and could potentially have their side done sometime tomorrow.
Yeah, that would make it about the halfway point in this trial. You know, the first witness on the stand today, McKenzie Anderson, she was on yesterday afternoon as well. So they picked up questioning of her again today. She's a BCA crime scene investigator. And we heard from her during the murder trial of Derek Chauvin too, didn't we, Rob?
Yeah, we did. She was one of those. There's been several repeat witnesses in this. So there's some new witnesses that the federal government has brought in, especially the expert witnesses. But a lot of the people that were involved in the investigation, whether it's the BCA or the Minneapolis Police Department, are repeat witnesses from that, going over much of the same information. But again, prosecutors going at it from a slightly different approach because they're trying to prove different charges, these constitutional rights violations of failure to intervene in use of force and a failure to provide medical aid or denying medical aid to George Floyd, not murder charges or anything like that. So the questioning is a little bit different. Some of the evidence or a lot of the testimony does end up being repetitive. So McKenzie Anderson talking about what she found during the searches of the 2 vehicles in question here, and that is the Mercedes SUV in which George Floyd was in the passenger seat on that day, where the officers took him out of that vehicle across from Cup Foods, and then the squad car that he was that they were trying to put him in the back seat. They put him in one side, and he was resisting and struggling and didn't want to be in there because he said he was claustrophobic. That's the first time he said he couldn't breathe, was in that back seat as they were trying to put him in there. And he worked his way through and went out the other side, which is how he wound up on the pavement on the street side of that vehicle. They tried to put him in from the sidewalk side, and he came out on the street side. So she talked about the evidence that she collected in the searches of the vehicles in the following couple of days, and then subsequent searches several months later.
Well, Rob, help us connect the dots here, because I'm having a hard time understanding how her testimony is really connecting to the charges of of those civil rights violations against George Floyd.
Yeah, and that is unclear for those of us watching here in court as well. You know, some of this is just to provide additional evidence and information and get it on the record for the jury. It may be relevant to other questioning or other arguments that they'll make, that the prosecution will make, maybe in closing arguments. The defense attorney's cross-examination, which was most of the morning that her cross-examination took place up until just before noon, really did focus too on the fact that there were some items, some pills that turned out to be narcotics that tested positive for methamphetamine and fentanyl that were not collected during those initial searches. There were some things in the Mercedes that were not collected in the initial searches. But what the defense attorneys really want to point out is that there were pills and there were portions of pills or substances that appeared to be chewed up and spit out pills in the back seat of the squad car that George Floyd was in briefly as he moved his way through. And what the defense is really pointing at here, what they really spent a lot of time talking about, especially defense attorney Pauly, is, you know, when these were collected and why they weren't collected the first time around. You know, how a crime scene investigator could miss those things that are obviously pills. She said initially her search was not directed, that narcotics wasn't part of what was on her list of things to look for. So when she saw those there, she didn't collect them because that wasn't really part of the scope. They were to the later searches. Again, there were later searches came up in December and then January as well. And one of those was defense attorneys wanted to look at the backseat of the squad car. That was in January. And then the BCA followed up right after they did with that. And that's when they found these pills and then the remnants of pills. The defense has argued, especially defense attorney Earl Gray, has made a case prior to this trial beginning about George Floyd ingesting narcotics to try to hide evidence, to suggest that that then caused the overdose, their alleged overdose, or the argued overdose here. But of course, we've had toxicologists, we've had
two, exactly.
We had the pulmonary expert,
We've had two medical experts now all talking that he died of asphyxiation and that the level of drugs in his bloodstream was far too low to cause any kind of cardiac arrest or death in this case.
Right, and that's specifically what the toxicologist from Colorado testified to yesterday, is that the levels of fentanyl and methamphetamine in his system were actually fairly low. In fact, they were, in terms of the fentanyl level, it was at a point that is on the low end of what they would use medically. They said it was between 10 and 20 I believe it was nanograms, and his was 11. So it was at the low end of what they would use medically. So he said that no, these did not cause any type of drug overdose. He didn't even think they really contributed to his death in any way. So it's kind of hard to know how they're going to then counteract that by suggesting that this occurred, and if they're trying to cast some doubt into the BCA's initial crime scene investigation, that it wasn't thorough enough. So it's kind of hard to see exactly how this might come full circle in when the defense presents witnesses. If this then is foundation for some additional lines of questioning with other witnesses and how that may play into it. But Earl Gray in his cross-examination early on this morning, one of the first things this morning, talks about the crumbles of pills that also contain methamphetamine. She said, I can't say how it got there. Earl Gray said common sense would say at some point this pill was in Mr. Floyd's mouth because his DNA was found on it, saliva DNA. She said, I think that's a fair statement. So that goes to then his argument leading up to this, that he was trying to ingest drugs. But again, how that plays into it in light of the testimony that his levels were too low to cause an overdose is to be seen, I guess. All
right, the second witness on the stand this morning so far, Lieutenant Richard Zimmerman. He's of the Minneapolis Police Department Homicide Unit, and he was asked about the duty of officers to intervene when they see excessive use of force by another officer. Walk us through that testimony, Rob.
Yeah, and that is very specific now to what are the charges here. A failure to intervene, and that is a charge facing J. Alexander Keng and Tu Tao. Thomas Lane is not charged with that failure to intervene, probably because he was the one that suggested rolling George Floyd on his side. I mean, we don't know that for sure, but that would be one of the obvious things that may have factored into that decision not to charge him with that. But the failure, the duty to intervene policy was put into writing in the MPD in 2016 by Chief Arredondo prior to him becoming police chief. He put that in there. But he was asked, he's been with the department since the mid-'80s. He said he's the most senior person in the department, and asked to define that. He goes, well, I think I'm the oldest one there, but he is certainly the longest serving person in the department.
Yeah, didn't I hear you say that once upon a time he started in law enforcement in 1981?
Yeah, I think it was 81, and then he came to the police department here in the mid-'80s. And he's been there. So he's been there a long time, yeah. And worked his way up and became head of the homicide unit as a lieutenant. But he said this duty to intervene policy, he said under questioning from the prosecution, trying to establish that this is something that everyone should know about, right? He said that it's been in his mindset forever, far before it was ever in writing in 2016 in the Minneapolis Police Department. Trying to find my exact quote here. He said he's known about it since he joined. When he became aware of the duty to intervene, he said the actual policy put into writing in 2016, but I've just done that throughout my career. What did having a written policy do to change that duty to intervene? He said it really didn't change anything. You have a duty to protect the public.
And apparently he was asked at one point about, this dynamic that we know took place there at the scene between Derek Chauvin, who was the field training officer overseeing these young rookies who are really into their first couple of days on the force. And he was specifically questioned about, is it more difficult for a brand new officer like that to intervene, especially against their field training officer, who is basically kind of their commander there at the scene.
Yeah, and that's something that the defense has made a point of throughout the cross-examination of this prosecution phase of the trial, is talking about what they labeled a paramilitary culture in the MPD, that it's very much you take orders and you don't question them, certainly in the training. And they got the training officers, the training people, to talk about how in the training period, certainly, you have to stand at attention and you can't speak, except at certain times, so that culture is there. And so that is something the defense said that they are really going to take an issue with, that the duty to intervene was barely mentioned in training, and that it's very difficult for these rookie officers, and that's Keng and Lane, who were just days into their actual full-time officer positions out of their training, to intervene with somebody like Derek Chauvin, 19 years in the department, their field training officer, somebody who's been kind of described as tough and intimidating. So he was asked, does being a rookie or being relatively new change anything with your duty to intervene? And he said, no. He said, rank, it doesn't change a bit. Is it more difficult for someone who's newer? The prosecution asked him, and he said, I don't know if it's more difficult, but it is their duty to do that. So the prosecution setting this scene here, that this is very much an overriding duty, that the rookies shouldn't be intimidated to do that. The defense has already made this point and will continue to make a point that these rookies didn't feel that they could intervene with somebody like Derek Chauvin and not have it come back to hurt their careers in some way.
Rob, he took the stand, Lieutenant Zimmerman, here about an hour ago. You're in the middle of the lunch break right now. Has prosecution finished up questioning him yet?
No, they're still going, and what they just started asking him about was another written policy with the MPD, truthfulness policy, and that's just labeled truthfulness, and went through that, some of the language on there, that it is that no employee, this doesn't just apply to officers, no employee of the MPD shall knowingly make an untruthful statement They shall not make any false statements to justify a criminal or traffic charge or to influence an investigation. They should not omit information either. And then they went right into playing Thomas Lane's body cam video from that night of May 25th, 2020, when Lieutenant Zimmerman arrives at the scene to ask them what's going on. And that's exactly what he says. He walks up and says, "What's going on?" You hear Lane's walking through the entire chain of events of arriving there because of the report of a counterfeit bill and getting George Floyd out of the vehicle, the Mercedes, and bringing him over to their squad, and how they were struggling with him. They said he was putting up quite a fight. And then, going down onto the pavement, you hear Thomas Lane, or actually you hear Alexander King, who you can see in the video, saying that he was on the ground and he was still moving. Thomas Lane says, yeah, he was still breathing too. And then they go right into telling him that the ambulance arrives and loads George Floyd up to go try to work on him. So they omit the portion of which George Floyd goes unconscious, and that they check for pulse and can't find it. They go right from he's still moving and breathing to the ambulance arrives. And I think that's what the prosecution is trying to get at here. We'll find out more as they resume this line of questioning after the lunch break, that they omitted information in their initial report to the head of the homicide unit who showed up to ask him about it.
Okay, splitting hairs here, and I appreciate you may not have an answer to this, and I don't either. That's why I'm asking the question. But that initial report to supervisor is that an official report? In other words, does it have less information in it than an official after incident report that they might write up later on for documentation?
And that's something I'm sure the defense will likely, take issue with too. Does this count, against them in this truthfulness policy?
Exactly.
If after, when they sit down and interview them after the fact, which they always do in a use of force or an officer-involved shooting incident here, where they then take a statement on the record. Now, this is all being recorded, and they would know that, so they know that this is all on the record stuff too. But yes, does this count as omitting information and violating the truthfulness policy, or is this just in telling the story quickly to the investigator, the homicide head that shows up on the scene, that just happened? But we'll kind of see. It doesn't look good for them. Again, got to wait to see how this applies then to a duty to intervene, and duty to provide medical aid. How they connect that in there too. But I think it may be just trying to set the stage for, maybe they were not trying to be fully forthcoming with all the events that took place there.
Rob, finally here this morning, I want us to take a step back and go back in court here to yesterday afternoon when an interesting development happened regarding one of the jurors. Could you walk us back through that, please?
You mean the juror that was
dismissed?
Excused from jury duty? Yeah, and that happened right away yesterday morning before this began, that the judge said that one of the jurors had a family medical issue, and that they've been trying to work through it, but that they may need his attention. And then got another message, a phone call or text message from his family saying, yeah, this is getting more serious. So the judge said, you know what, you need to go take care of that and excuse that juror. So that means we now have 12 jurors and 5 alternates rather than 6. Obviously the judge wanted extra alternates here in a time of COVID, but this was another situation that required, having extra jurors on there. Certainly helps in this case. He did mention this morning, before the jury was brought in, that he had heard from that juror and that the family situation was going well. Just to tell everybody that that this is. He'd heard positive things from this juror that had been excused as an update. But yeah, so now 12 jurors, 5 alternates is where we stand.
That was a very nice update from Judge Magnuson there. Rob, thanks so much. We're going to let you go catch some lunch because I know court's going to be coming back in session here in about another 45 minutes. So we'll have a complete wrap-up tonight on Fox 9 at 5 o'clock, and we'll be back here at approximately the same time tomorrow afternoon. You can catch us here, of course, on fox9.com and on our YouTube channel. And we'll bring you a complete update tonight here on Fox 9 9 News. On behalf of everyone here at Fox 9, I'm Tim Blotz. Have a great afternoon. We'll see you later this afternoon on the air.